We gotta get him to stand up there. Yeah. Good. All right. So I got the thumbs up. I think we're ready to start. Project. So I need to speak louder. Okay. Can everyone hear me in the back? Good. Cool. All right. So who's ready to learn about the thrilling world of startup law? Oh, yeah, I knew it. I knew you guys would be. I knew it. I've actually been rewatching Suits for probably the 12th time through now, which I need to stop doing because it frustrates me on a few levels. One of which is that you expect your life as a lawyer to be as dramatic as an episode of Suits. I think we're missing background music, like we just need violins playing or something whenever we make a decision. So that's one thing, is that it's not as dramatic as one would think. It's often there's a lot of reading through documents, trying to understand laws. And the other aspect that I don't like about it is that everything that they do is wrong. So I guess that's the first bit of advice, is don't take your legal advice from an episode of Suits, because it will lead you astray. And I guess in light of talking about Suits, I was telling the students earlier today that we want to make people as captivated in the world of startup law as possible. And the threshold that we're trying to set for ourselves is to be as captivating as an episode of Suits, but actually telling a true story. So that's the bar that we're setting for ourselves. So try to keep us on that level, and we're going to try to be as thrilling for you as possible. And with that, we're going to go into the super exciting and mandatory aspect of legal presentations, which is the disclaimer, which I'm going to read to you verbatim just to keep things nice and interesting. Just kidding, I'm not actually going to read it verbatim, but as is mandatory with most legal presentations, we're giving you a disclaimer saying that this is not legal advice. This is just general information, and we're not soliciting you right now to be a client. This is not establishing a lawyer-client relationship. This is just meant to be fun and give you a really high-level overview of the law and how it pertains to all of your ventures. I guess as a starting point as well, how many people here are working on a startup right now, just so I can get a sense of that? Okay, good, perfect. So this is made for you and with you in mind. Basically, we want to give you the tools that you need to understand your venture from a legal standpoint. So just to kind of give you a little bit of a run of show, I'll start by talking a little bit about myself, and the bulk of the content is going to be gone over by our startup legal strategists who are right here. But for a bit of history about the Startup Legal Support Program, Startup Legal Support Program came about from me actually doing a cold email to the DMZ saying that I wanted to help entrepreneurs understand their legal needs in a way that is comprehensive and accessible. And that actually came about from my experience as an exited software entrepreneur that saw the barrier that I faced in terms of accessing legal services, and that was the next problem I wanted to solve. And over the past 3 years, we've been able to build that out by creating this in-house legal clinic for startups that are part of the DMZ ecosystem, supporting them with a variety of legal needs as their fractionalized in-house counsel, and reimagining legal services by creating this really approachable and comprehensive legal service that resonates with founders, which we've been able to do alongside our partners at MT Ventures, who are also rethinking the way that the law is done. So with that, I will invite my friend Ishan Karnik to talk a little bit about MT Ventures.
Just being kept for me. Hi everyone, my name is Ishan Karnik. I work at McCarthy Tetrault in their startup division labeled MT Ventures. Part of what I do is I work exclusively with startups. All my clients are startups, and we see them through from seed rounds all the way to Series C. Our goal is to sort of act as their external GC. And we help them. So for my background personally, I'm a corporate transactional lawyer and a little bit of a commercial lawyer, but our goal at MT Ventures and at McCarthy Tetrault, of course, is to make sure that we see them through in all aspects of their needs, whether it be from just an administration perspective or from a commercial perspective or from a securities perspective. We really want to see our clients succeed. And working with the DMZ over the last year and this fantastic team of students has been incredible. You're in a really, really fortunate place in this incubator especially, just based on the level of resources you have. So I'll be around. I'm going to be hands-off for the presentation. I'll let these fantastic students take care of that. But I believe there's a portion towards the end where I was voluntold to be available for any questions you had, and hopefully be able to answer some of them. Like any lawyer, I may have to cast away most of them, but I'll try and be as honest and forthright as possible. But enjoy. They have a fantastic presentation for you guys.
Thank you, Ishan. I tried to negotiate as much question asking ability as possible, so we'll try and get as much as we can out of Ishan. But yeah, so basically the takeaway is if you're part of the DMZ ecosystem, you can come to us for legal support. Externally, firms like MT Ventures are a great resource that are also finding ways to help entrepreneurs. So now for the agenda, and eventually I will stop going through all this stuff and we can actually learn a little bit about the law, but not yet. So for the agenda today, you can see we have it broken down, and this is basically meant to simulate the startup process, the startup legal roadmap. So starting with foundation, when you have your idea, what that looks like, what things you need to be considering at that stage, and then moving on to share capital, which we broadly called share capital because it was something that we found that founders find very exciting, is when we talk about shares, it's a good way to keep people engaged. And then moving on to next steps, which is once you've had your company established, once you have started understanding how to use your shares, how to grow as a company, what the future looks like in terms of things that you need to consider in terms of the legal aspects of your business. And then of course we have our MT Ventures panel down here where you get an opportunity, the rare opportunity to ask a lawyer a question for free. So there we go, take every advantage of that. And this is my last little bit here, and I think we are fine to share these slides with you, but if not, then feel free to reach out to me directly, and I'm happy to share this particular slide with you because this is just a general breakdown of the types of contracts that you need to consider when you're going through your venture. So a lot of the questions that come up for us is just people have something and they know that they need to be considering something legal. So hiring an employee being a really basic example, or issuing shares, and they know that there's something legal that they need to be considering, but they're not sure exactly what that is. So what this list is meant to do, in no particular order, but kind of a general roadmap, the things that you would need to consider and the actual tools that you could use to achieve those specific goals. And we'll touch on each of these to some extent throughout this presentation, but this is just a helpful kind of catch-all of all those things. And now with that, I'm happy to hand over the reins to the illustrious startup legal strategists to take it from here and teach you a little bit about startup law.
Hello everyone, my name is Devraj, and thank you, Nick, for the introduction. I was told to make this captivating as possible. Might not happen, but keep with me, and we'll try our best here. So I just want to tell you a little bit about myself too. My interests are in corporate law and tech, and that's what drew me to work with startups here at the DMZ. And also, I love that the passion that the founders all bring motivates me to do my work and help them kind of grow their company as much as possible. So what we're going to start with right now is the foundation, so of the legal journey and things you should consider at the beginning. And mostly what we'll be looking at is kind of protection and risk reduction. So the first thing that we turn to is the founder's agreement. So I'm hoping that everyone in this room, whether you're a founder or not, that you've heard of what a founder's agreement is and that you've come across it at some point in your legal journey. But for those who may not know, it's essentially an insurance against, and this is in the words of the great Nick Hill, and you might not take this quote directly, but you can't predict the future, but you can control the present. So what is a founder's agreement? Why is it important? Just some key points that we kind of highlighted for this is that clarifies each owner's role in the business, which is very important to understand what the relationships are between all the parties, provides a structure for resolving any disputes amongst founders. Also, it outlines the intention of how, at the early stages of business, how everything will be allocated, provides clarity of if and when, which happens regularly when a founder wants to leave or even join. It also indicates to investors that you have a serious business, and that's very important when you're trying to get financing in the future. And lastly, which could be the most important point, is that it puts everything on the table. So after the founder's agreement, something that you might have come across, and I hope that you have come across at some point, or produced on your own, or given to somebody, or maybe received at some stage of your legal journey, is the covenant non-disclosure agreement. So we made this slide purposefully dramatic with the black background and all, because what we think is like, so many founders come to us and they show us this NDA, the non-disclosure agreement again, and then when it comes to it, it's like, they're like, what do we do with this? How important is this? And like, we kind of want to outline some of the key, what the importance are, and also some of the key limitations when it comes to the NDAs. So when it is an NDA, it's important because this is where your IP is your most valuable resources. You don't want to give it out to anybody. You don't want every listening ear to kind of get a hold of what your secrets are. But to understand with that, there are limitations, and what you can and cannot do. So for those of you who may not know, an NDA is a legal document, and it's supposed to protect your sensitive information and help you maintain your competitive advantage as a founder. There'll be specific confidentiality written out in the agreement, and it creates a trust relationship. And that's what I kind of see the NDA as its most important kind of role, that you're putting everything in writing, and not everything, like the handshake to me is very important, but to some people, they might break that deal. So, you want to put everything in black and white where possible. And the exact nature of the information itself can also be outlined within this agreement and bind parties for a specific time. And even going without any such agreement, any information that may be divulged to any third party, to the public, can negatively affect your competitive advantage. And that's something that at the onset you want to protect as much as you can, especially with something that you feel like is a unique and key idea to yourself. So you might ask, do I need an NDA? And if the last slide didn't sell it to you, I would say yes, you do need an NDA. However, beware of the limitations. It does give you certain recourses against the person signing it, but not to others. And one analogy we use, you cannot put the genie back in the bottle. Because why? Because once someone has heard it, the third party ears have come to it, that can be spread to whoever. So you can hold those who are the signing parties accountable, but not necessarily anyone else in the room. So if you're talking about at the next DMZ social, then you want to make sure that you're keeping things like secured as possible. And again, the NDA shouldn't be your only form of protection. There's other resources as well, like an example, patent protection or trade secrets. A story that we have in the legal folklore is that one of Coca-Cola. So I don't know if this is somewhat of a myth. It might be true, might be not. You guys fact check me later. But that that Coca-Cola, their formula was never actually formally patented. However, they've managed to keep it a secret for over 136 years through their trade secret. Very few people know about the Coca-Cola formula, and I think how they've structured is like someone knows the first half, someone knows the second, and only together will they actually be able to ever make Coca-Cola. But that's a different idea than the NDA. Maybe don't just spread it on like that. Maybe come to the formal resources that you would have within these legal documents. And now, again, you ask, do I need an NDA? And like I said before, yes. However, understand its limitations. So the NDA is a deterrent. Even if it isn't bulletproof, it does have some ability to offer you protections. And what I see most important of it is the peace of mind that it offers. The takeaway here that you may need to disclose certain information to investors and advisors and other founders alike. However, you don't need to give away the secret sauce. Okay, so because again, if your recipes do get out, and even if you have an NDA in place, it's very difficult to put that genie back in the bottle. And another point, or the last point on it, is that NDAs are only as strong as your ability to enforce them. So that's a key point to understand when you're drafting or negotiating an NDA. If you sign, like an example, this might not be a case if anyone's working with Amazon, but if you sign an NDA with Amazon and they breach it, how likely is it that you will win the court case? Maybe, maybe so not. The legal juggernauts that they have, though, might make it very difficult for you. So it's something to keep in mind, that it really depends on the relationship you're having with the other party, who you're working with, and what you're actually telling them. But again, not everyone is Amazon. They're not going to have the same legal team. They're not going to have the same kind of intentions in mind. And people do respect the NDA and its power as a deterrent. And having one in place gives you the opportunity to have to pursue kind of legal action against the breaching party. All right, so now the last point about the foundation that we're going to turn to is the incorporation and the importance of it to become a corporation. So as a separate legal entity, you can now, as a corporation, give loans, take loans, enter contracts, sue people, be sued, hold assets, and all on behalf of the corporation, and keep this liability away from your person. There are risks in business, as I'm sure you all know. However, the corporation can help you protect yourself against these risks. For example, as a proprietor, your personal assets may be seized to pay for business debts. We generally prefer to keep your personal and your business assets separate and can save yourself from personal financial loss. However, in instances where the corporate veil may be punctured, or i.e. Where you may personally be on the hook for liabilities that cross past the corporation, such as there's unpaid wages, unpaid taxes to the government, if you're in a secured loan, and if you offer personal property as collateral. One thing to keep in mind, always read the fine print, or even better than that, have a lawyer do it. Kind of moving forward, even with corporate incorporation, because there's a few slides on this just because it's so important. What else does it offer? It gives you investability. Incorporations are considered, or as we consider, the gold standard for investability in businesses in Canada. Not that the investors don't want to invest in you personally or directly. I'm sure they love you and they will, but it's all about liability. And I think this is one of the most important reasons for incorporating. And as we talked about before, splitting the personal and the business is important here, and it provides even investors with the limited liability that they won't lose more than what they've put in. Also, it gives you a little bit of flexibility to transfer ownership and assets, and this is important when you're trying to invest external investment. And lastly, it also helps you establish credibility, which is very important when people are trying to ensure that you're serious about your business. And the corporation, here, more important aspects of the corporation, it helps you hold what you've developed for and as your business, ensures continuity. So as we said before, founders come and go. You want to make sure that everything remains the same and the ship is kind of run in the same direction, regardless of how the team changes. Without a corporation too, your intellectual property and other critical aspects relating to your business might be just held by individuals on the board, but you want to keep it so that's within the corporation and not just to any person running around in your office. So the key takeaway here is that with all of this, all those points that we made out, they don't just happen automatically. It needs to be enshrined in a contractual agreement, and your articles of incorporation, your NDAs, everything that you drafted, the founders agreement, all kind of play a role in tying that together. For our next thing, we're going to go over share capital, and I'm going to hand it off to my friend Bella, who's going to take over from here.
All right, hey guys, thanks so much, Deb. That was very interesting, and it's not an easy topic to make interesting, so sorry. If anybody can't hear me, just like put your hand up and I'll talk a little bit louder. Awesome, thank you. So I am a little bit more fortunate. I get to talk about financing and the monetary aspect of running a business, which I think engages people a little bit more. So I'm a little bit more lucky on that end, and hopefully I'll make it as interesting as I can. A little bit of background on myself. I did come from a business background and a finance background, and then I started working for a startup kind of in its early stages upon graduation, and I really loved that environment, so that's kind of what brought me here. And so without dragging this on anymore, we'll get started. And just before I start talking about share capital and all of the important aspects of that, one thing that I do want to touch on is the minute book, and the reason for that is that a lot of the documentation that goes along with issuing shares is important to be kept in the minute book for a few reasons. Primarily for you as a founder, if you're someone that's starting a company, it's really important that you have all your documents in one place, that you have everything very well organized, and that you know exactly who you've issued shares to, at what cost it was, at what date. If you have options holders and they've exercised, you want that all documented. It's also going to house just kind of everything that gives someone a really good and clear picture of your business and everything that's gone along with it, from your articles of incorporation all the way up to share transfers, share issuances, board resolutions. So if you're issuing shares, those are a few other things that we'll get into, but there's a lot of documents that will go along with that, as well as any amendments to your articles of incorporation. So everything like this is really important to keep on top of, as well as when you start raising capital. This is something that your investors might be interested in seeing, and so you want to make sure that you have all the information for them readily available, because it just makes you look better, more of like an outward appearance that you're organized, you have things together, people want to invest in a company that they can trust is well managed, and that's a really good way to reflect this. Okay, so first we're going to start with understanding your shares. So our lovely founder and leader Nick likes to reference Mark Zuckerberg when he started Facebook and handing out shares like he's Oprah. And Nick tells the story much better than I do. But essentially what's important to note there is that issuing shares is much more than just handing them out to anybody that wants them. There's actually a formal process that goes along with it. And so it's really important to make sure that you understand those documents, you understand the rights that are involved with each of the shares that you issue, and that you kind of have everything together on that end. So we'll start out with authorizing shares. So typically when you file your articles of incorporation and start your company, you're going to decide initially on which share classes you're going to be issuing. Typically, common and preferred shares are what most founders will think about at the outset. Obviously, as you go further, your share structure is going to get a little more complicated, but to start off with, those are usually the ones that people keep in mind. And what's important to note there is that if you have only one share class, there's 3 sets of rights that are important to be associated with that share class. They can be divided between multiple share classes if you have them, but let's say you just started with common shares, infinite number, so you can restrict them or not, but let's say you started your company as many common shares as you want to issue, you have to make sure that those shares have the right to vote, the right to receive dividends, and the right to some kind of piece of the pie if the company is dissolved. But let's say you had common and preferred shares, maybe common shareholders only have the right to vote, and the right to liquidation assets upon dissolution and the right to receive dividends is exclusively for your preferred shareholders. You could do that as well, or divide them if you had a more complicated share structure. And then for subscription, so this is kind of where you get a little bit more into the documents that are really important that you have housed in your minute book and that you keep track of. So your subscription agreement is like your offer to engage in this purchase of shares, and you would issue those to anybody who you're issuing shares to. It's pretty simple for early stage companies, but that doesn't make it any less important. So that's just something to be really mindful of. And then for founder shares, it's a good idea that you also have them for that. You can have them decided in your founder's agreement, but better safe than sorry, and especially coming from a legal perspective, we always like to tell you to err on the side of caution. And if there is an option to have that document, you should probably do it. And then your share issuance is the actual, like it sounds, issuance of the shares. A lot of early stage companies will issue their shares for pretty much $0, but you do need some kind of compensation in order for that agreement to be binding. And so you could issue X number of shares for $0.0001, but some money needs to be exchanged in order for that to actually be a valid transaction. And so that's another really important part about this. And depending on the way that you've structured your classes, you can either issue share certificates or not. You can issue uncertificated shares, but essentially what a share certificate is just proof that your shareholder owns the shares they say they do. If you issue uncertificated shares and your shareholder asks for a share certificate, they are legally obligated to receive that. That's just another consideration. It's not, super important, but it is just something to be very well aware of. And then understanding your share classes. So we're just going to go into this a little bit deeper, common versus preferred shares. So common shares typically will have voting and rights to some residual profits. But one thing that is a little bit different from common and preferred shares is that preferred shares will have some kind of set dividend. Even if you don't issue dividends to your common shareholders, your preferred shareholders will still get a dividend. Even if you choose to defer, at some point you have to pay it out to your preferred shareholders. And they usually get priority upon liquidation as well. So if you are to liquidate your company and you allocate some of that money to your shareholders, they get preference on that. And that's also something that can oftentimes be negotiated with your investors. If you're issuing a certain share class to them or preferred shares, they might have something to say about, what kind of liquidation preference they get. So common shares are no guaranteed return and they're last in liquidation, but it's also just as valuable of an equity tool. And there's also some other options. So most commonly with early stage companies, you hear a lot about equity issuing shares to your shareholders. There's also debt, which sounds scary, but it's not necessarily a bad thing. It's just an institutional loan. It can be secured or unsecured. You do have to pay it back at some point, whereas with equity, there's something else being exchanged. So that's where I think people get a little bit more antsy around taking on debt. But it doesn't have to be a scary thing. You just have to be mindful of what your obligation is to whoever you're borrowing from, whether it's like who you bank with, financial institution. It's just important to know like what your rates are, if you have to collateralize your loan, something to be aware of as well. Unsecured loans are also an option, but usually the interest rate is higher, so that's something to consider as well and what you're comfortable with, and also how much capital you need. And then there's also derivatives, which is something that I think a lot of people often have questions about. So a couple that are pretty common. Options is the first one. So a lot of times you'll hear about early stage companies that issue options to their employees, which basically means that they have the option but not the obligation to purchase shares. And that usually happens on a vesting schedule. So let's say over a 1-year period or a 6-month period, however many months someone has worked with you, they are vesting or accruing a certain number of shares that they're able to then purchase at an exercise date for a certain price. But they're not just being given the shares or granted the shares or buying them outright. So that's an important distinction. And then also safes is something that I think a lot of people have a little bit of confusion with. So essentially what it is a simple agreement for future equity, and it's what it sounds like. It's a very basic agreement that's very founder friendly and very early stage company friendly. And essentially what that is your investor will say, I'm going to give you X amount of money in exchange for equity at some point in the future based on a triggering event. So let's say at some point in the future, you raise money from a VC. At that point, you're going to issue me X amount of shares, X percentage, and that's kind of distinguished by either pre or post money valuation caps, which is a little bit more nitty gritty, but the important thing to remember with safes is just the fact that it's probably something that if you're starting a company and if your early stage is going to come up, because it's a lot easier for you, it's a little bit less technical, and it's very founder friendly, which is great for somebody who's just trying to finance their company on the early stages and needs some kind of capital infusion. And if you have more questions about that, of course, that's something that definitely you want to delve into, but it does get a little bit technical and I don't want to overly confuse people because I know this is already kind of a complicated topic. And now we're just gonna really quickly, I know I touched on this, but just kind of distinguish between debt and equity because I think that's something that's commonly the question that young founders are gonna have or early stage founders are gonna have is the distinctions between the two and when to issue or when to seek one over the other. So equity is less risk and you don't have to pay back anything, but it's also diluting ownership of your company. So you have to give something in exchange for this money, and often that means giving up some form of control of your business, depending on your founders' agreements or how you've structured this at the outset. You might have some anti-dilution clauses in your founders' agreement, but you are still giving something up in exchange for getting that money, in exchange for that you don't have to pay it back at some point. Whereas with debt financing, you get to keep full ownership, there's less dilution, it's like a typical bank loan, like you would understand if you were taking it out for, you know, a school loan, just a little bit more complex. And the interest is tax deductible, so it's another important consideration. That's something you're concerned about. But it can cause cash flow problems depending on how long you're going to need the money for or what amount of money you need. And so those are just some considerations in terms of where your company is at and what stage they're at and what your needs are going to be, and also what your projected growth is going to be, your cash flow, and kind of what stage you're at and what you're comfortable with at this point. And now this is also, apologies, a little bit more technical and probably a little bit more intimidating to founders, but it's also extremely important. And this is government regulations. So the OSC has quite a few rules on how you report things to them and how you manage your company and especially your share capital. But there are some exemptions. So typically when you're issuing shares, you have to file a prospectus, which is essentially the information about your share issuance filed with the government. But there are some exemptions to this. So first of all, friends and family, if you wanted to issue shares to your spouse or brother or your partner, you don't have to file a prospectus. If you're an accredited investor, so angel investors are something that early stage founders will typically run into, which is essentially just a high net worth individual that is giving you money from their own personal net worth. So they're not representing a company, they're not running a fund. It's just them investing in your company. And I believe there's some threshold that they have to provide as to how much their net worth is. Private issuers, so if you have less than 50 shareholders, that's also an exemption, so you don't have to file a prospectus. So especially with early stage companies, that's pretty common that you typically wouldn't have over 50 shareholders yet, unless you're like Mark Zuckerberg and just handing them out like crazy. And then most recently, and this is kind of a unique one, is crowdfunding. So typically you would be over, or predictably would be over that 50 shareholder threshold if you were crowdfunding and using that as a way to issue equity, but this is also an exemption. What's important to know here is just to be aware of what your obligations are, especially when it comes to government filings, and be aware of when your situation is going to change. So if you're in this boat now and you don't have to file a prospectus and you can have an exemption, you should also be aware of when these exemptions no longer apply to you and when it's important to start filing that prospectus, because getting in trouble with the OSC is not recommendable. So these are just some things to be really mindful of, and I think these are also typically all very applicable to early stage founders. And so most of the time with early companies, what we see is that they are available, these exemptions are available to them. And so you should be in a little bit of an easier boat, but as that changes, it's something that you definitely should be aware of. And just finally, I'm going to go through some alternatives. So let's say you don't want to take on debt, you don't want to issue equity. You can engage in some kind of partnership with another business. So joint ventures are when you pool resources together to get to some kind of goal or engage in some kind of business activity. Partnerships is probably one that's more common and you're going to run into at some point, because partnerships are pretty much ubiquitous in most businesses and especially in tech. That can come from channel partners, resellers, agency partners, system integrators. So let's say I am going to market your product to my clients as well, or I am a value-added reseller for your product, and my sales team trained in order to also be able to be licensed to sell your product to my clients. And then strategic alliances is kind of similar to joint ventures in that it's two companies that are kind of working together on some kind of mutually beneficial project, except for the distinction is that you're not going to be sharing resources, you're kind of just working towards one common goal. And the idea behind this is that someone has capital, someone has some kind of strengths that you don't have, and instead of going out and getting this funding externally, you're going to work together to either reach more customers, better provide for the customers you have, and just kind of enhance each other's product offering without taking on any kind of other obligations. Now I'm going to hand it over to Sean for our next steps.
Thanks, Bella, for that. How's everyone doing? Okay, can everyone in the back hear me? Yes? Amazing. There are so many people here. All right, so really quickly, we're going to imagine, if you will, you're a founder, your company now is starting to receive investments, you're ready to launch your product. What do you do? This is what my stage is about. So we're going to talk about the shareholder agreement. A shareholder agreement is not a founder's agreement. We really want to stress that. It's similar, but they're not really the same thing. So what a shareholder agreement really governs is the relationship between your company and all of its shareholders. So the shareholder agreement works as a document in conjunction with all of your articles, your bylaws to govern the entirety of your company and things like that. So what we should think of it is we should think of the shareholder agreement as having a deterrent effect. It resolves disputes. So by having it set up earlier on in your company, it makes it a lot easier as you're moving down the line to start taking on investors, because you're not really building a shareholder agreement while you're in some type of dispute, which can be a very problematic thing for you. So we recommend generally that people contemplate what this document looks like earlier on. And some things to note is that, once again, this is not a legally required document, but it's a document that most companies will take on just because they want to avoid those issues later down the line as they're taking on investments. So what can it do for your business? Really quickly, the shareholder agreement actually helps with decision making. So some of the ways that it does this is it actually contemplates kind of what I would call like the W5 and H, so like who, what, where, when, why, how much of your business as it relates to shareholder issues. So things like, who can be a shareholder, how much would it cost to be a shareholder? Like really you can break down all those questions and all those iterations. That's the purpose of the shareholder document. In terms of in practical things, you can actually think of the shareholder document as also contemplating what kinds of issues require shareholder vote. How many shareholders have to vote for an issue to actually pass? So these are the types of things that it will deal with. They actually will help you along the line of your company to support those decision-making issues. Some of the issues that actually also they're contemplated by the shareholder document is that some shareholders may want a right to be consulted in order to make some type of business decision. What that looks like is something that there's different forms. I'm not going to get into the nitty gritty. I'm trying to think in the high level, but that's something that the shareholder agreement would typically try to contemplate. Also, whether or not certain shareholders can appoint directors. That's also something that the shareholder agreement would contemplate. A big point for some investors, or most investors, is dividends. So the shareholder agreement would actually point out the threshold points of when dividends would be paid out, and how much and to whom. So on the point of restricted transfer and ownership of shares, the shareholder agreement has a number of different provisions that manage share ownership. And some of these mechanisms are voluntary transfers of shares. The purpose for that is to safeguard the transfer of shares to third-party competitors, for example. You don't want a situation where some member of your, you have a major investor, and out of the blue they decide to sell to your main competitor, and now you're in this weird situation. So the shareholder agreement protects against situations like that. The mechanism that they use are things like right of first refusal, tag along and drag along rights. I won't go into any detail about those things. You can ask us later on if you have specific questions, or a lawyer. But suffice it to say that there are mechanisms in place that protect founders from those situations. As well, there are situations where there may be compulsory transfer of share necessary. An example of that is you have a director who is a major holder of shares and now wants to leave the company. And they maybe just joined a month ago as a director. Do you really want them to walk away with those shares, or do you want those shares to either go back to the shareholders or the company? That's another situation that the shareholder agreement would deal with, or could deal with. In terms of financing, all you really need to know about that point is that this is really a tool that's used for fundraising. We talked about voting ability, we talked about limits, we talked a bit about those components, but it's incredibly important that the shareholder agreement contemplate those issues. And most importantly, because you all are doing this because I think there's usually an endpoint, the shareholder agreement governs your exit strategy. I cannot emphasize that enough. To some degree, it will put limits on how your exit is structured, or how your exit would look like under certain situations. And that's provisional on those other conditions we talked about, the right of refusal, these kind of conditions that govern how shares are exchanged between parties. Okay, so that was shareholder agreement. Now we're going back into the point where your product has been launched and now it's available to the public. There's some considerations that you have to take in mind. First is the idea of privacy. So under Canada, we are governed by PIPEDA. That's the main privacy legislation. That legislation is right now in the process of being updated. Right now, I think it's in the second reading, Bill C-27. The bill will not be ready may not be ready, will likely not be ready by the end of this year. So just keep in mind that if you do have a privacy agreement, it may be apt to change within the coming year. So just keep that in the back of your minds. If you don't have one, you're probably going to have to change it once you develop it in a year. So everyone here will have to change the privacy policy, or at least review it. What PIPEDA manages is privacy, things like where data is housed, how data is used, what rights individuals and users, so regular people, have towards those data. Other considerations for privacy that are really important is also the places of business that you're operating in, or the places where your users are living and residing in. So there's legislation that exists in continental Europe, in Singapore, in Hong Kong. There's legislation in California that really governs the US around privacy. So all this to consider is these are some of the things that you should be thinking about when developing your business or thinking about bringing your items to market. Also, personal information, that's also important. We talked a bit about that. Personal information is just information that, generally speaking, that users give about themselves, name, phone number, anything that's tied to an individual. All of the things that I've talked about around privacy typically focused around personal information, with the caveat that the new legislation that's going to be introduced will also be focused on algorithms and how those kind of like secret sauce pieces operate in the background. So just keep an eye to that as well. Okay, terms of service, terms of use. So a terms of use is not a terms of service agreement. They're similar but distinct. What a terms of use agreement is it's kind of just like the terms by which an individual may use your website typically, or your app typically. If you've ever read one, who here has ever read a terms of use agreement? I genuinely want to know. Okay, wow, that's more than I actually thought. So a terms of use is typically written in plain language, so really easy. There's not a lot of like legalese, and the reason is you want whoever's reading that, the person on the other end is likely going to be someone who's unsophisticated, which just means they're not a lawyer, and they're zing. No, but the whole point of that is you want to make it actually accessible to everyone. So that's why. So there tends to be a lack of legalese, and it's written for the common folk. But that's a good thing. I don't know why everyone's laughing. That's great. The terms of service tends to be more of a technical document. It's written with more legalese, and the reason is because it is more of a beefier document in terms of separating what your obligations are to the clients. And it can cover everything from like confidentiality to payment terms to points of dispute. It's a broad sweeping document, so it's written more opaquely generally because it just has to do more heavy lifting. Talk about that. Okay, really quickly, some really quick tips on your terms of service agreement. When you're thinking about your terms of service, really write out all of the things that your service provides and all the things that you are going to do in relation to your customer. So all the obligations that you have and all the commitments that you're going to make. And then on the other side, write down all the ways that your customer will be interacting with you. And then that will set up the types of things that your terms of agreement will have to be contemplating. And that's a really quick and easy way for you to like at least start to understand what you need to be including in your terms of service agreement, rather than just showing up and saying, I need a terms of service agreement. Like it's always a good idea to understand what your agreements are doing, because at the end of the day, it's your business, and you're going to be responsible for it at the end of the day. Okay, now we're going to talk about building a team. So you launch your product. You now need individuals to help support that launch. So you're recruiting. You're building a team. One of the things that you're going to want to consider is compensation. In some cases, you may want to provide equity to individuals who are working under your employment. We do caution everyone that although that's a common preference, the Employment Standards Act requires individuals to still receive some minimum payment. And that's for employees of the company. So we generally recommend that people avoid just providing shares in lieu of like any payment. So payment with shares if you are deciding to pay with shares. That's the general kind of rule based on the Employment Standards Act and the obligations such as minimum wage that apply to anyone who's working in Ontario. Other things that you're going to have to think about is whether or not you're going to be hiring employees or not, or whether you're going to be hiring third-party contractors. There are different obligations that employers will have or companies will have towards either one. There's not really a cut and dry line between who's in a contractor and who's an employee. So be careful if you are hiring someone as a contractor, depending on what you're asking them to do, they may in fact be deemed to be employees under the law. So it's not as simple as just handing them a piece of paper saying you're a contractor. Now you're going to show up 5 hours a day, every day. I'm going to determine when your breaks are. I'm going to determine when you can take vacation. All of those like little things that start to look like employment would make a court believe that actually this person is an employee and not a contractor, despite the fact that you've contracted with them as a contractor. That's a point of caution that I always share with folks. Other things to consider, some general provisions in your agreements, things like non-compete clauses are important, non-solicit clauses, things like defining what the term of the employment is, what the term of the contract is if they're a contract employee, terms around IP, just defining what things, especially in tech, what things, what types of work the individuals producing that belong to the company versus what they can keep for themselves if you desire them to keep things for themselves. I think carving that space out is really important because when you've neglected those little things, you can have trouble down the line, especially when you're launching new products or when people leave and they, sometimes will go off and work for competitors or work with other third-party party providers within the same sector or space as you. So really important things to consider. Finally, this is important just because of the nature of startups, grants. Looking at you because you reminded me of this one. So there is a program launched by the government of Canada that allows startups to hire students at a heavily discounted rate. I believe the rate is like 70% of their wages covered by the government of Canada. Amazing program. Under the rules of that program, if you were to hire an individual, that person is an employee, not a contractor. So just keep that in mind because that's really important. Within the sector, individuals tend to be hired as contractors. So we just don't want people to be remiss that by employing students, they would then be contractors. The government requires that they be employees, which would mean that you would then have to take off things like HST, GST, taking off all the applicable taxes and kind of abiding by what other employment regulations, what employment requirements are required for that person. Other than that, generally speaking, whenever you're taking any government loan, read the fine print, just to ensure that if you use those dollars to hire individuals, there isn't a requirement that you have to have them on as employees. So that's kind of the take home. And with that, passing it back to our esteemed leader.
Thank you. All right, common folk. How are we doing? Still fairly peppy, even. What's that? Oh, no. Where are we at? Okay, here we go. Cool. All right, well, I actually noticed at the beginning, because I was referenced a few times here, I didn't actually introduce myself. So I'm Nick, that they were referencing throughout. It's a pleasure to meet you all. And yeah, just kind of going through what everyone talked about, I think the real takeaway is just be aware of the nuance and be aware that even though it may not be top of mind, there are probably legal elements that are applying to you at any stage of your journey. And for the last personal anecdote for me for the day, when I had my venture, I was going through it with two technical co-founders who generally liked to be involved with the business and ideation side of things. But one thing that they decidedly had no interest in being involved in was the legal aspect. And they couldn't stress that enough, to the point that there was a time where we had to consider developing a privacy policy, and they asked me, do we actually need a privacy policy? Let's just forget about it. To which I had to respond saying, yes, we absolutely do need a privacy policy. So we went through and drafted that ourselves. So just being aware that these legal elements are incredibly important and not always top of mind, and finding things like the SLS or like MT Ventures that will support you in understanding what you need at each stage is invaluable. So hopefully you were able to take some of that away from today. We're going to be around. Ishan's going to come up and field some free legal questions, which I can tell he's excited about. And we can go into some of the more nuanced things here through questions, because there's also a lot of legal jargon tossed around. So if there's anything that was unclear throughout the presentation, feel free to bring that up at this time. Otherwise, we're always around the DMZ and are happy to discuss these in more detail. So, I had one more slide. So I guess this was just kind of looking to the future. So things that you want to consider here, just like I was saying before, once you've established a corporation, once you've issued shares, you have your NDA, you have your contracts with customers, your journey doesn't end there from a legal standpoint. There are things to consider going forward, right? As your company evolves, so will your legal needs. So these are just general things to know. Like Bella talked about, managing your securities with the OSC, which is the Ontario Securities Commission. As your corporation changes, as your number of shareholders change, your requirements to the Ontario Securities Commission will also change. Things like your terms of service, which Sean touched on, will change as your company continues to grow, as you offer new services. Your existing terms of service may not cover those new services, so making sure all of those things are up to date. And same with your corporation, like Dev touched on, that will also evolve considerably over time. So just making sure that you know that because you've done all this legal work, your journey doesn't end there. You just have to be aware that your legal needs will evolve as you do. And now, with that, I will invite Ishan back up for our Ask a Lawyer component, and I'll stay up here while to help you out with questions.
Yeah, happy to field some questions. Again, I think everyone did a fantastic job in summarizing what legal world looks like when it comes to startup law. Just to be clear, from a legal perspective, and as lawyers, our goal is not to slow you down. For each of our clients, they see firms like McCarthy Tetrault, they see, big fancy law offices and They think that this is going to prevent them from focusing on their product. Part of what we do at McCarthy and at MT Ventures, and what I do with my clients, is I tell them that, look, our goal here is to make sure that your legal debt is at a minimum. By legal debt, all we mean is that you can continue focusing on your product and you don't have to worry about all those legal concerns when it comes to transactional securities or employment work. So again, not trying to hold anyone back. And when we do onboard clients, and when all of you get to a stage where you are looking to a firm like us to handle your legal needs, our goal is to work with you and not against you, and that should be every lawyer you meet. So that being said, happy to answer questions in the best way I can if there are any in the audience here.
Maybe whoever wants to go, raise your hand.
Perfect. We have one right over there.
Yeah, I'll start us off.
Yeah.
I guess what are some common legal mistakes that you might see startups making, and how can you go about avoiding these?
Oh, it's a really good question. So the first thing that I do when I onboard clients is I do something called corporate cleanup. And it dives into their minute book, their corporate records. I'll speak up here. The first thing I do is I do something called corporate cleanup. So that's where I dive into the minute book of the company. And the biggest mistake that I see from startups is not keeping an accurate minute book or an up-to-date minute book. A lot of people see your incorporation documents. We call them incorporation and constating documents. Basically, all your agreements should be digitized or kept in one giant folder for us to make our lives a lot easier. If I don't know who you've sold your shares to, if I don't know who your employees are or what agreements govern them, or if I don't know where your shareholders agreement is or who signed on to that, that would make my job very difficult, and that would make your job very, very difficult itself, because you might have an employee saying, hey, we agreed to this, or you gave me 20% of your company and I don't have the agreement here, but it was promised to me in an email. None of that works. The best thing you can do is just keep accurate records and keep all your agreements clean and appropriately done. The second one that I'll quickly touch on is, it's an awful thing to say because lawyers are expensive, but get help and get resources. I have clients every day who come to me and say, hey, I sold X amount of shares to this person. I don't really know what I did or why I did it, but it was just something to do that I heard was a good time. It's never a good time later on. I'll have to go in and find out what the terms were of that sale, what this shareholder will have a right to, and now that shareholder sits on your cap table, and your cap table is sort of the governing chart of your company. So now you have to go to that shareholder every time you want to make decisions. So even though it may not be affordable to see a lawyer, try and do some research yourself, or just find resources like the SLS to speak to and to get a good idea of what exactly you're doing and how the best way to do it would be. Those are the common mistakes that I see. All right.
One quick question. First of all, you guys are all fantastic. Thank you for the presentation. And basically my question about foundation phase. And so let's say, specifically about a template for founders agreement. Is there like a generic template that we can grab? Obviously, it should be tailored to like specific needs more, or it should be developed from 0 to 1.
That's a great question. So should it be developed from 0 to 1? Not necessarily. So a founder's agreement generally has the same terms and principles. It's not going to be an extremely comprehensive 100-page agreement, but there are certain terms and conditions in there that you need to be relatively well versed in. If it comes to a template, I believe the SLS has a template for a founder's agreement that we've actually reviewed. The great thing to know with templates is that they're a great start, they're not a great end. Take the template, use the template, but make sure you understand it and make sure your questions about it are answered. I frequently have founders come to me saying, hey, I signed this document, but I don't know exactly what I signed. Now, a lawyer's job is not only to help you understand what you signed, but also to just keep it in very simple English, very, very plain, and make it understandable for you, because at the end of the day, you're the one who gets to face the consequences of what a signature would entail. We get to sit back and just give advice. So make sure that not only are you using a template, but you're really understanding the terms that come along with it. And especially when it comes to founders agreements, we're all human beings and founders will fight. I'm sure those of you who have companies know what that's like. and fighting is very commonplace. What is not recommended is contention when it comes to dismissal areas. So it's fine to argue with founders, it's fine to have all those mini issues that you have. What you don't want is a founder to leave the company and say, hey, I'm owed 50%, and you have no idea if that's true or not. So that's the goal of a founders agreement, to set those terms straight. And a template like the one that SLS offers is a great place. But if you want to make sure it's airtight, speak to a lawyer, get their services. It's worth every penny. All right, anyone? Okay, so we have questions. I'll go over there. Yeah.
Okay, thank you. Thank you very much. It was great. I have two questions. One is smaller, the other one is more complex. First one is, we talked about updates in legal documents, like in terms of news. What were the documents that you have at a timeline that you need to update, like annually, or just when you really need? Like, so this might be only when you have like a change. You have something that is very like crucial to update like in a specific time. That's the first question. And the second one is, I work with international entrepreneurs, supporting them to apply for a business incubator in Canada. So the clients are not in Canada, and most of these startups are globally. So when we are talking about customers, for example, agreements with customers, what is valid? Is it Canadian law, or should we like consider that all the terms that we are writing in our documents platform, for example, would also connect the agreement with international clients?
Yeah,
Two great questions.
two fantastic questions. Updating agreements. Updating agreements, I can't think of any that you should be thinking of on a specific schedule. Terms of use, terms of service, and a great way, and I think what I tell clients all the time is, if you don't want to get, if you don't want to hire a lawyer to do, pay them, a pretty penny to get work done, go on to Airbnb, go on to Twitter, go on to Facebook, go to their terms of service, see what they have. Go to your competitors who are more established in the field. It doesn't cost anything, but you can see how they run their terms of service, and you can see not what you should copy, but what you should have an idea of. You can speak to your lawyer a little bit more intelligently and say, hey, I noticed that Facebook does this, we don't. And a big thing that those companies sometimes have is have an effective date at the top of their terms of service, or have a last updated date. It really depends on your business. Has your business changed over the last year? Are you offering new services that you didn't offer 6 months ago when that contract was drafted? That's when you're going to have to make updates. A big thing that startups do is constantly adapt and change, but their agreements need to adapt and change with them. So if you've created a terms of service 6 months ago, but now you've instituted a new product and a new model, you're going to have to update that. Secondly, I completely blanked on what the second question was. International law. International law, yes. So that really depends on a couple things. It's called contract residency. That's what we call it. It depends on the agreement. Every agreement has something called a governing law clause that shows, okay, this is governed by the rules and regulations of the province of Ontario, and it has something called a jurisdiction, so it's governed by the courts of the province of Ontario. So if your contract says that the contract is governed by the province of Ontario, then that's a factor in a court making a decision that the province of Ontario will have the residence and the jurisdiction to govern this contract. It depends on a variety of factors. You'll see that some people frequently pick places like the Bahamas,
Tax havens.
tax havens. Yeah, none of that works. Don't do it. It doesn't make any sense. If your company is based in Toronto and your client is based in New York, the Bahamas has nothing to do with those two places, and it's not going to kick in by some magic word that you put in there. So it is a variety of factors that come into play. Most importantly is an appropriate governing law and jurisdiction clause. So check those. Hope that answers the question.
Yes.
I think we have time for maybe a couple more.
I think that's it. No more questions.
No more
but,
questions.
We are sticking around for good co. So if anyone's around, we're still going to be around for some questions. If you want to just come up and chat with any of us, I think Ishan has to hop out for a bit, but then might be coming to join us later. And just a reminder to everyone that we are doing these workshop series at the last Thursday of every month, followed by
by our good co, so feel free to join the next few workshops. But thank you for coming out to Startup 101, or Startup Law 101, and we hope to see you at the next one.
Thank you for joining, everybody. We got